Okay. And you were coming. Wow. Okay. All right, good morning.
Good morning.
My name is Bruce Adelson, and today we're going to talk about the Americans with Disabilities Act, the year in review. So it would be helpful to me before we get started, if you go around the room, introduce yourselves, please, and tell me where you're from. So let's start with you. Okay.
I'm all Russell, and I'm the director of legislative people.
Okay.
My name is Greta Paxton. I'm an intern at Wilson County Community
That's me. I run my own small business, Future Visionary Solutions.
Good morning, my name is Michelle White, and I work at the UAW in our Civil and Human Rights Department.
Good morning, my name is Cynthia Harris, and I work at the Civil and Human Rights Department, also for the UAW.
Well, my pleasure to be here. It's always a pleasure for me to come back to Michigan, particularly when I get to be re-educated, reacquainted with your weather. Because I had a little car trouble this morning, but it reminded me of all the car trouble I had when I used to live in France. So, and this is who I am. I'm a former U.S. Department of Justice Civil Rights Division senior trial attorney. I'm the CEO of Federal Compliance Consulting, which is based in the Maryland suburbs of Washington, D.C. I'm the testifying and consulting expert in a lot of Americans with Disabilities Act litigations across the United States, and I was recently appointed an instructor of family medicine in the Department of Family Medicine at Georgetown University Medical School. And I also most recently taught at Cornell University. I teach civil rights awareness, implicit bias, and cultural competence primarily for healthcare. Okay, so that'll get your attention as we get started, the money and the gavel. The Americans with Disabilities Act is one of the most hotly litigated federal civil rights laws today. It is literally, I've learned about new cases every week. It is, I don't want to say it's remarkable. It's not surprising because the ADA, as it's structured, is very plaintiff friendly compared to many other civil rights laws. You have to prove a lot less to win. These are the big hits that are going on right now. Effective communication, which we'll talk about. Federal enforcement, the ADA is a federal enforcement priority nationwide. Huge source of lawsuits, as I said, and those mainly concern effective communication, meaning communicating with people with communication disabilities, and websites. Is your website legally accessible under the ADA? That is a huge area of federal litigation. There are already 1,000 cases filed this year. That's a record compared to the record of last year. I expect the number to continue increasing for the foreseeable future. And as I said, ADA healthcare litigation really leads the way among federal civil rights laws. It is just a huge, huge, huge source of activity for my lawyer colleagues. Part of the reason that the healthcare is such a big focus for the ADA is the Affordable Care Act, Section 1557, which became federal law 2 years ago. The ADA makes it easier to sue. Affordable Care Act makes it easier to sue. The standard for that you have to prove, they have to reach is lower than it used to be. It is still catching a lot of healthcare providers by surprise. I recently had a conversation with leadership of a large West Coast hospital, and they were really unaware of the changes that now affect them under the Affordable Care Act that makes them easier targets than they had been before. Essentially one of the biggest changes that healthcare providers generally don't know is the Affordable Care Act changed the legal requirement to make healthcare providers have the same obligations as like Macomb County, as state and local government. Big change, really big change, and gives healthcare providers more responsibilities, more obligations than they used to have. And as I suggested earlier, the reason that the Affordable Care Act is a real boon for lawsuits is it just makes it easier to sue and makes it easier to win and recover damages, and then of course attorney's fees if you are on the losing side. And websites, as I said, and this number is now a little bit out of date. It is just a very hot area of federal civil rights litigation. Why? Because the Department of Justice decided this year that it would not provide the explanations that it had been promising for a long time about what exactly is an accessible website under federal law. What do you have to do to make your website accessible to people with disabilities? That's unclear. What is not unclear is that you have to. So if you think about how crazy that sounds, you have to make your website accessible. How you do it is unclear. And it's almost a case-by-case thing, because the Department of Justice has said, sorry, we're not going to give you the information that we had been promising about how to make your website accessible. So it's not a question of if you have to, there's no doubt you do. How you do it, that gets more complicated. And this will just give you a little bit of a flavor of this. So I can win in a federal court in Ann Arbor. Okay, and let's say you have a multi-state business, and you also have offices in Indiana and Illinois. And the court orders you to fix your website in Michigan. Well, I can sue you in Indiana, federal court in Indiana, because your website at your office there is not accessible. You can say, hey, wait, Bruce, wait a minute. You already sued me in Michigan. You won. Here's what we agreed to do. And I would say, not so fast. That's in Michigan. We crossed the state line now. We're in Indiana. We're in Indiana. So what are you doing here? So I could pop you in all the states or all the counties, even if I were not suing in federal court, if I were suing in circuit court about your website. And so that's part of the difficulty. Also, of course, the internet goes everywhere. This is a good example. I got a call recently from the owner of a New York City restaurant who had received an email from someone in Florida that this person could not access his website, couldn't read his menus, let's say, or figure out how to make a reservation. Now, this person had never been to his restaurant, nor had he ever contacted the restaurant. He sued the restaurant, saying the website is not accessible. The owner was just beside himself about being upset. I've never seen him. He's told me he's never been here, but he's suing me. So can you get rid of this? And I told him, well, I can't just snap my fingers and get rid of it. It's going to cost you, it's expensive. And you have a defense, possibly, because this person has never actually been in your restaurant. So I think we should come up with a pretty good defense about that. But that gives you a flavor for why this is so big now and so difficult. I could never set foot in this building, yet I could sue this office in Macomb County if this office's website, for example, or the department's website, is not accessible. Now, I might not win, and there are defenses to that, which we're not going to go into. But this gives you an idea of why not only this is so complex, but why there are so many lawsuits. I could just spend the day looking at various websites online. And it's not, if you know what you're looking for, it's not really hard to figure out what are primary issues about websites that can be targeted. And then I can just sue each place with a website if I choose to.
Can I ask you a question first? Just hypothetically, that case in New York, let's just say the gentleman is planning to go there.
Right.
And he's trying to find what restaurants he wants to eat. I mean, that's an argument, and I know you say you're not gonna get into that,
But you're forcing me to get into it, right?
I'm just thinking, I'm like, you wanna plan where you go when you travel.
Well, and that's a good point, and that is one of the things that the plaintiff claimed, that he was planning to come to New York and he wanted to check out restaurants. Yes, and you're right, that could be a viable explanation. That could be something that complicates the case for the restaurant. But what has happened a lot, and the courts are starting to look at this more, if I literally drive by this department, I never come in here, and I never really had an intention of coming in here, or at least something, I hadn't planned on doing that like today. Maybe I plan to do it in 6 months or a year. And I say, wait a minute, there are X, Y, and Z issues. That's a little bit different than this, but it really gets into some complicated issues legally called standing. That do I have the right, the standing to claim that this website is affecting me? Because I've never been there, and whether I plan to go there or I'm planning to go there next year, does that give me the right to sue now? So that's one of the complicating factors. What I'd like to do, my goal is to get through the slides as quickly as I can. And there are some that I'm going to spend more time on than others, because there are some things that are a little complicated. And then I want to give you a lot of opportunity to ask questions. So I appreciate your question, and if there are questions that I can deal with quickly, great. But otherwise, I'd appreciate if you could hold your questions until I'm done, and then we can get into as much detail as you'd like. So this is one of the examples of something that happened this year. This is a lawsuit against Dunkin' Donuts by someone with a visual disability. It's called the case of Haynes versus Dunkin' Donuts. This was a decision of the Federal Appeals Court in July. So the plaintiff, the customer, is saying that Dunkin' Donuts website doesn't allow me to access it. So I can't figure out where their locations are, for example, how much a cup of coffee costs. I can't access their information the way someone can who does not have a visual disability. So the customer claimed that the inaccessibility of the website has denied him and other blind people the ability to enjoy the goods, services, privileges, and advantages of Dunkin' Donuts. Among other things, he's claiming that Dunkin' Donuts website allows customers to locate the physical store locations, the addresses, and maybe you can actually click on a link and go to the store's website. Maybe the stores have some differences. Purchase gift cards online. Customer claims that Dunkin' Donuts website provides access to and information about Dunkin' Donuts business, what they sell, what they provide to customers. And he's saying, of course, well, I can't read any of that because the website is not accessible to me. I can't read the website with my screen reader. So that's discriminatory. The court agreed. Virtually every federal court has said the same thing, that the ADA covers websites and that websites have to be made accessible. As I said, the complication is, how do you do that? And in what time frame do you do that? That's where things get nasty. And this will give you just a little bit of a more of a flavor of what the courts are really saying about this, and commenting on what the Justice Department has said before. What exactly does this mean? The Justice Department has never really said specifically what is an accessible website. Now, of course, they talk generally about what the federal law says about accessibility for people with disabilities. They never really explained this in the sense that what is a violation of accessibility. You can have a website with hundreds and hundreds and hundreds of issues. Do you have to fix all of them? Do you have to fix them all today? That's one of the things that is still nebulous. So just because a website goes down, does that mean you're discriminating? So your internet connection fails. Or there's some other issue with your website crashing. Is that discriminatory? And the courts are basically saying no. That, of course, we all experience crashes. We all experience the connectivity issues that we do in just day-to-day life. So that by itself is not enough. And this is the last point is important. There are no standards that the Justice Department has put out, no regulations about how long a temporary failure, how long a temporary website crashing has to be before you can say, whoa, that website has crashed, now it's discriminatory. Is it a day, half a day, 2 hours? Nobody has really said that. So that's really a case-by-case thing. So you can imagine for all of you, if your website crashes right now, you could think of it as like the clock is ticking from a liability standpoint. How fast do you fix it? How do you accommodate people who cannot use your website? Do you have folks who can answer the phone, who are trained to help people with disabilities? If you don't, that's a problem right off the bat. So this is an important question. How do you accommodate people with a disability when your website stops working? So now let's go into one of the, this is also a case from this year to show you a little bit about how broad the ADA is, how many things it applies to, and how you may not think, your first reaction might be, oh, how can they sue over that? Well, this is a good example. This is the how wide are your aisles case against the retailer Kohl's. So in this case, Ryan was the customer, claimed in the lawsuit that she could not access Kohl's merchandise because the aisles between merchandise racks were too narrow. So she had a wheelchair, could not get her wheelchair, she said, through these spaces. On one particular visit, she said she was unable to get close to a mirror to look at how she looked in whatever clothes she was trying on because of where the racks of clothes were placed. Were they in front of the mirror? Were they side by side the mirror, but the space between the racks was too narrow to allow wheelchair capacity? So Kohl's answered by saying that she could move without difficulty on the main aisle. Imagine this is the main aisle of the store, so she could go back and forth here because there was no impediment, no racks blocking the aisle. She never measured any of the aisles to say, wait a minute, this aisle is 16 inches wide, this aisle is 20 inches wide, so therefore it's narrow, it's too narrow. And she did not ask anybody for help and didn't try to go down the aisle that she thought was too narrow. So if you think about a couple of logical issues with what Kohl is saying. So Kohl's is saying that the customer has to take out a tape measure and measure the aisle and say, hey, Kohl's, this is 16 inches wide, too narrow. I don't really think that's a good argument. Never measured any of the aisles, did not attempt to proceed down the aisle. So you can imagine if I put chairs here and you were in a wheelchair and I said, for you to have a case that this is discrimination, you have to go down the aisle in your wheelchair. And you might say, well, Bruce, it's too narrow. I can see that. It's tough. You have to go down the aisle and experience this issue yourself. And I don't really think that's a good argument either. And that you never asked for help. That's something that you'll see in a minute. It's what the court addressed. So what Kohl's is basically saying is, you, the customer, have to prove to us that you can't get down the aisle. And you have to prove to us that you asked anybody you could see for help in getting you where you needed to go with the mirror, for example. So the courts decided, this is in Illinois, that Kohl's does have this service counter where you could go ask for help that is legally okay, and a written policy that employees use it to help people when they're requested. But the customer said there's nobody there. It's rare that someone's there. And using it is impractical for her because there are these stacks of merchandise, so she can't get there. So you can imagine that if you all in the back are at the counter, and I'm the customer in a wheelchair, and there are things blocking me from getting to you. So am I supposed to like wave my hands and raise my voice to get your attention? No, that's not what the ADA is all about. So the key is that here, the court found ADA discrimination because the counter wasn't regularly staffed, it somehow was forcing Ryan, the customer, to go to extra measures to get help. And yes, some of the aisles were too narrow. So if you can imagine, next time you go shopping, or really the next time you're just out and about doing your thing, think about how broad the ADA is to cover what happened in this case. So that if let's say the aisles should have been 30 inches wide and they were 29.5 inches wide, Kohl's loses. They could have a compliant customer service counter and a policy that about helping customers, but if no one's there, Kohl's loses. I'm also going to show you some, and this is one of the things I'm going to show you today, an example of some things that have come up in some of my litigations that really are not public knowledge unless you happen to like looking through a lot of court dockets and reading stuff that's been filed in cases. But this is an example of something that a hospital used as a defense in a lawsuit by a deaf patient, saying that you did not provide me with effective communication, which is the legal standard. So I want you to read the policy. This is just the sentence. I'll talk about it in a moment. Qualified interpreter will be used in any and all situations where clear and effective communication is necessary. And then they have a list of like 20 times or 20 situations where they will use an interpreter. This is a big part of this case. What do you think is good, bad with this statement?
It's too broad. There's
Why?
not enough detail. It doesn't really explain. In what situation will they give a person help unless the actual comprehensive list is there as well?
Yes, it is.
Okay.
And I didn't put it here just as I'd have to have 3 slides for the list. So let's say there are 20 things on the slide, on the list. And a great list that it lists all kinds of situations where, yes, you will provide me with an interpreter. So they have a list that's very comprehensive and it fits the detail issue that you picked up. And hold on. And they say that we will use an interpreter in each one of these 20 situations. Yes. And that's a good point about using phone. That's not something we're going to talk about today because this is only about the Americans with Disabilities Act. If this were a spoken language situation, you'd be right on the money, I think. But here the patient is deaf, so a conventional phone isn't going to work. And that's not the method that the hospital chose to use to communicate.
Does the hospital know that he's deaf?
Yes.
I think the issue of the hospital is defining the method of communication and where it applies, and that's not the case. It's really, the burden is on the hospital, is too wide, and I think the deaf person is the one, under how the ADA defines reasonable accommodation, that said that person would say when he needs effective communication.
Okay. Well, the deaf person in this case said, basically, I want an interpreter in all situations. Remember they have that list of 20 situations. So let's assume that the deaf person has said, I want an interpreter in all 20. What do you see as an issue with listing the situations and saying, we will give you an interpreter in all of them? Yes, that's a very good point, and let's see if we can kind of go to the next step with that. You're right, there could be a 21st situation that's just not there. Now, that didn't come up, but think about what did come up.
Do they have do they have a full-time person on staff,
Yes.
24 hours?
Let's just say yes.
Okay.
And that's not an issue with availability, which
Okay.
does come up a lot, yes.
Okay, I think that's the same vein I was in, because just that statement there, a qualified interpreter will be used in any and all situations where clear and effective communication is necessary.
Right.
Where clear and effective communication interpretation is necessary every day, all day. So their statement really should be an interpreter there 24/7.
And that's a great point. And let's, I think you're close to what I'm looking for. You're right. Keep in mind though, they had this list of 20 things. The case was about the patient saying, you did not provide me an interpreter as you say you will.
Exactly. Because
Yes.
they said in any and all. clearly.
Yes.
Is the interpreter meeting the right metrics for qualification?
Yeah, that's not an issue.
Not an issue.
That's a good point. It's not an issue. But I think as some of you have picked up, the problem with doing this, it sounds great, but unless you do this, you're
Opening yourself up.
you're opening yourself up for the kill.
Very broad.
Because that's what happened in this case, that you can have a policy like this, which is consistent with the law. And then you list all these times you're going to provide an interpreter. What if you don't do that? So what you've done is legally, you have a policy where you say you will do something. You have a policy that you violate. It makes it much easier for you as the hospital to lose. So yes, policies are very important. The courts are looking to written policies more and more and more, but you better make really sure that you are complying with your policy. Because when you get into court, everything's on the table. Your emails, your phone messages, everything. Hospital record, patient record, medical record. And if you have a policy that should have fit this situation, and it says you would do what we've been talking about, and you don't, then what's your explanation?
So is that why you see a lot of policies that say we may, or we shall, or we may?
That's very good. So you're right that they're saying you have to do it in all of them, which is legally required. Now, a lot of people just don't know that. A lot of hospitals, frankly, don't know that. If the law said may, you're right, then putting that here would be important. But the law says shall, so if effective communication is necessary, you shall provide effective communication. Now, frankly, the law doesn't say you must use an interpreter in every situation where effective communication is required. You must provide effective communication, which could be an interpreter, it could be written notes, it could be using universal symbols to explain something. But if it's required, which it's going to be in most cases, then you have to provide it effectively, meaning I, as the patient, have to understand what you're trying to tell me. Yeah, this is something in an email from a high member of the leadership of a large hospital in discussing the Affordable Care Act and the Americans with Disabilities Act. This particular leadership representative said, are there laws that we're not following? Now that was already suggesting that this person thinks that we're not doing something we're supposed to. And the response was, oh yeah, these are the laws we're not following. Really? What are we not doing? There's this long email string where they're talking about, oh, we violate the law, we didn't know about this. You can imagine that if you discover something like this, let's say you're on the hospital side, how do you explain it? If you're on the patient side, you get all excited because that's a great admission that the hospital is discriminating. It would be very difficult, as it was in this case, for the hospital to explain, well, you knew you were violating the law. You knew there are laws that you're not following, but you didn't do anything about it. And that's why we're in this particular case today. In another case, one hospital defendant never provided in-person interpreters. Flat out, they just never did. And why? Because they were concerned about the cost. In this particular area, they were having some issues with interpreter availability and getting interpreters relatively quickly. And one vice president of the hospital said, It takes 5 hours for an interpreter to get here, so we don't even call them. Now, this is not in a rural area. This is in a large metropolitan area. So I'm a little skeptical, and I was at the time, about the 5 hours thing. But what's the issue, if you know legally, about doing this? About never providing interpreters, either through video remote interpreting or in person? Can you do that? Is there an issue with that? What do you think?
Not necessarily, as long as you provide some type of communication to a person that needs it. You don't have to have an actual interpreter, but as long as I believe, based on what I know, is somebody there to provide some type of communication, you're compliant.
Well, you're right in saying that the law is effective communication. So if you have a communication method that is effective, yes, that can work. But there is a problem with never providing interpreters. What do you think it would be?
That be case by case, because what one person needs as effective is different than the other individual.
That's a good point, yes. In some ways, it is a case-by-case thing.
Would it be the cost? It will put that company in jeopardy just because of the money, they just don't have the resources.
A lot of organizations say that. For healthcare, for state and local government, cost, for the most part, is not a reasonable excuse. There was a case, it's a little different, it's an employment discrimination case a couple of years ago against a large, well-known university teaching hospital. And a nurse who was deaf applied for a job, and she was declined because she was deaf. And the hospital said it just cost too much to hire an interpreter for this nurse. She won. And the court said, basically, this organization, this entity, has $2 billion in annual revenue. So the court basically said, are you telling me that paying $60,000 a year, which is, I think the court figures like 0.007% of your total revenue, is an undue burden? No way. She wins. So cost is and can be an issue, but as my friends at the Justice Department said, it cannot be used as an excuse to do nothing. There are ways to look at it, and we're not going to talk about what would be an undue burden, what would be too expensive. What I'm getting at is that quote, that this hospital, as an informal policy, never provided in-person sign language interpreters. Is that legally okay? Is that legally okay?
Yeah.
And well, hold on, to take your point one step further, you're right, providing effective communication methods is crucial. One of the methods of providing effective communication is interpreters. And I may be giving away the store a little bit. So if that is one of the methods to provide effective communication, if I come in and I'm deaf, can you tell me we will not provide an in-person interpreter? Period.
Yeah, you can call it on the phone.
Well, remember, this is sign language, so that's a little different. Can you, if you raise your hand, then I'll tell you the answer. Can you tell me I'm deaf? I want an interpreter. Can you tell me we never provide an in-person interpreters? I mean, legally.
What
not-
kind of organization?
Well, no. You have to answer the question. Who says, yes, you can do that? So you're all looking at each other, what you all are doing. Who says
Say
that?
yes if you.
There's no qualifications. Can you say yes to me, we do not provide in-person interpreters?
Say yes,
Yeah.
as long as you can find another method of meeting the accommodation for effective communication for that person.
Who says no, you can't? Why?
The reality is a different thing.
Not reality, we're talking about the law.
Well, you know, and this is from clinical experience, it's not from, that people usually get what they want at the end of the day, despite the fact not a lot of people are experts on multi-represented. So faced with that dilemma, many clinicians will just choose to go the route that they will provide an
And then they provide a 24/7 interpreter,
They end up.
and they pay $50,000
For
for a multiple day stay.
Yeah, I mean, the fear is behind, many people are aware of litigation issues, and we might get sued, we might get supervised airplane, so they get intimidated into the situation and they end up doing that. Now, that's why I said reality. Now, as far as law, like the gentleman said, as long as we provide a good method of communication, effective method of communication, good.
You know, with the scenario that you were going to if it was an emergency situation, and this person was
That's different, and I agree with you. It's not emergency. So the legal answer is no. You cannot say we never do this. And very simple. You're right that you could have all these methods of communication that objectively are effective. But in-person interpreters is a recognized method under federal law for communicating. So to say we never do this, you're taking off the table what federal law says is an option to meet for local, state government and healthcare providers. I decide basically, how to communicate, not you. So you can have all these other methods, but I could keep saying this is not effective for me. And I could have, and I'm talking about having a legitimate reason for it not being effective. Taking something off the table that legally I have a right to, you can't. Maybe we communicate in other ways, but you can't just tell me flat out, we never do this, ever.
What about the private sector? Because I know you keep emphasis on the local, state, and hospital setting. What about the private sector?
Private sector is covered by a different part of the ADA, and let's say you're a restaurant or a hotel, for example, and I come in to check into the hotel or to have a meal. You're not required to have an interpreter. That the standards are different. That's why when I mentioned the Affordable Care Act before, 4 years ago, healthcare providers had the same standard as a restaurant. Not anymore. They have the highest standards, the same as state and local government. Many healthcare providers don't know that. And they still don't know that, even though the law has been the law for more than 2 years. So you're right, private business, much different. I'm not focusing on that today.
Focusing on the city, state, and hospital setting.
City, state, county,
and hospital
and
setting.
all healthcare, not just all healthcare providers
Gotcha.
who are, get some kind of federal subsidy. That could be like Medicare, Medicaid reimbursement.
But Bruce, your question was, can a person walk into a hospital and say, I want an in-person?
No, that wasn't the question. The question was, can a hospital refuse in all situations to provide an in-person interpreter for a deaf patient? The answer is no. Because it is a recognized method of communication. It is pursuant to federal regulations. And you don't have the right anymore as a hospital to say, we just don't do this.
So what if the other way around, the person walks in and says, I want an in-person interpreter, and you said, well, there's other methods of communication that would happen, and I'm not ordering.
And then I'm going to say, I'll see you in court. That's what happened here. The explanation is not legally defensible. There's no way it takes 5 hours for an interpreter to show up. This particular hospital used that as an excuse. But this is a large city, about the size of the population of Detroit, maybe a little bigger. There's no way that this is true. I know that that's not true.
You know, but I'm with that statement in the sense of the reality of a certain situation, especially in the state of Michigan. Now, the first part might be good, I mean, to me, from a clinical perspective, but to get here, so we don't call, that's a no-no, we have to call. Take the state of Michigan, we have a total of 257 medically endorsed interpreters. We have patients who are waiting days to get an interpreter, so we do document all the time. But right now, what I heard you say, this even might not be defensible in case somebody walked into my hospital and said, I need an interpreter. I can't provide him one because I could not find an interpreter.
Because, well, let's look at it in a couple ways. The legal standard is effective communication. If I tell you that communicating with me by video remote interpreting, for example, is not effective, and I have objectively reasonable explanation for that, I could have a visual disability that I can't see the computer screen, let's just assume that. Or my medical condition doesn't allow me to raise myself in bed to see the screen, let's just assume that. Then the fact that there are, whatever the issues there are, and I know what the system is in Michigan for certifying interpreters, you still come down to the bottom line legal requirement of effective communication. I can't use the VRI, so it's not effective for me. I have a visual disability, so I can't see written notes. Many people who are deaf, who were born deaf, cannot read English effectively. So then what are you going to do? Are you going to be like the surgeon in some cases that I see, that as the patient is being wheeled into the operating room, because there is no in-person interpreter, or because the video remote interpreting isn't working, the surgeon is madly using her hands to explain where she's going to operate on the deaf person? No way. So the fact that you may have in-state challenges because of your state law to interpreter certification means what should you do? Deal with the state agency about these requirements, and if you can show that these requirements are somehow unduly burdensome or restrict your ability to hire and retain and bring in qualified sign language interpreters, then you may have a federal lawsuit of your own against the state regulations. Do you hire and retain your own in-house interpreters? In a state like Michigan, no matter what your state law requirements are, federal law, of course, trumps state law for the most part. The fact that you may have onerous state law certification requirements doesn't release you from your effective communication obligation. So it always comes down to that same bottom line issue. Is this effective for me? And if I'm telling you it's not effective, and my explanation is reasonable, what are you going to do? You can't do nothing. You can't continue to use the VRI if I keep telling you I can't see the screen. I can't read the notes. I don't understand. You know, the doctor has told me I'm going to die in 6 months. I can't understand this 10-page written note explaining to me the diagnosis. So that's part of the big change in the law. 3 years ago, you would largely be right. You're not right today. The federal court decisions basically line up. They all say the same thing. The standard is effective communication. Now, frankly, there are some folks who will just want an in-person interpreter all the time. The law does not say that. So we're talking about situations where the explanation, the excuse, the rationale for wanting an in-person interpreter is legally valid. That it's just not working for me, it's not effective, and that's objectively reasonable and correct. But you just focused on what is the focus of these cases. The biggest, remember, the two biggest areas of federal litigation under the ADA are effective communication and website accessibility. The effective communication issue comes up, as it did here, is they don't use in-person interpreters. They rely exclusively on VRI. Now, they do it because of cost. Leadership decided this is too expensive, we don't want to pay for it. This was a very expensive case for them. So, and they settled, but the case was not necessarily going to go well for them if they went to trial. So maybe they saved $100,000 last year, but they blew that out the window with the attorney's fees and the damages. In this case, it was probably over $500,000. This is from last year, but it gives you, this is also a good explanation. This was also a federal appeals court case of how some providers approach this. So in this particular hospital, Bethesda Hospital, was sued by a deaf patient. And they not only decided to only use VRI because it was more cost effective, they also had problems with the VRI, it just wasn't working properly. So one day, Gary Ridson, the vice president of risk management, was told of a few cases where the VRI didn't work. And he was also told that several patients refused to use the VRI. They wanted an in-person interpreter. So he was really upset about that. So what he did is he wrote his own sign and he posted it in the hospital stating that patients who prefer an in-person interpreter rather than video remote interpreting must pay for the interpreter.
Did he get fired?
That I don't know.
That's this
You
dog.
don't put it
You
in
put it in
writing.
writing. They're gonna like-
Yeah, well, so I don't have to ask you what you think of this, because I think you all kind of,
Opened itself up.
yeah, and then you all kind of nailed it. Not surprisingly, the Court of Appeals really liked this one.
My question, where's the legal counsel in that hospital?
That's a good question. My experience, that this is just like a lot of areas of the law, it's a specialty area. And a lot of, in my experience, well, I won't say that. I will tell you what an in-house general counsel told me. And this was after they had been sued and they got slapped with multiple Department of Justice investigations. His explanation was, I'll be honest with you, Bruce, I don't know about this. This is not my area of law. I don't generally have a federal court practice. So we recognize we need outside assistance to understand this. I'm going to just leave it at that. I think that his comments are very consistent with comments from other hospital general counsel or outside counsel that hire me as their thought process of these cases. Many outside counsel hospitals are very expert in negligence and medical malpractice. This is not medical malpractice. The laws are different, standards are different, and it's not state law, it's federal law. Federal law is very different than state law. So he was just very honest with me about it. He explained they had lost the Court of Appeals case, and then the Justice Department came in, and they were just getting hit left and right with investigations and then with that lawsuit. So he said, we finally realized after all this litigation, we don't understand this well enough to handle. So as I said, his comment is consistent with what others have said, and I'm going to just leave it at that. I won't characterize it either way. These are these are allegations, and actually this is a federal lawsuit that recently ended, very recently, just in the last week or so. But these are some allegations made by a deaf patient about the use of video remote interpreting, just to give you an idea of, and these are pretty common allegations in most of the cases that I see. So again, these are allegations. Don't assume that they're factually correct, but these allegations do come up pretty regularly. So video remote interpreting wasn't used during treatment. The staff didn't know how to set it up or how to use it. Even when it was used, there were technical and logistical difficulties that made it an ineffective form of communication. So patient is sitting on the magic words here and saying it was not effective for her. The video remote interpreting device was taken away at night and it wasn't brought back until the next day. Patient requested an on-site in-person interpreter so that she could understand the medical condition and the treatment that she was receiving. Oh, we'll get to that in a minute. So this is relatively novel. I don't really see that this is discriminatory. The VRI devices belong essentially to the hospital or the provider or the organization. Hold on. And if they decide to take it out of the room, they can do it. So it doesn't belong to the patient. This did not prove to be any significant issue in the case. The requesting an on-site interpreter so that she could understand, as we've been talking about, communication potentially in other ways than an on-site interpreter. To nail it, she has to say this, that the VRI never worked, it was ineffective for me, written notes are ineffective for me, the only way I could communicate effectively is with the in-person interpreter. So these are, except for the one at the top, these are relatively typical allegations that I see all the time. VRI is not working, staff didn't know how to use it, the picture was blurry, I need to have an on-site interpreter, an in-person interpreter to communicate effectively. They didn't provide one, or they didn't provide one often. So these are pretty good summaries of what I see like constantly. In all the cases that I've had this year, all of these allegations, except the first one, have come up in every single ADA healthcare case. Then you get into, well, are they correct? And what are the explanations behind them? Because one of the things that the Justice Department taught me when I worked there is very interesting to look at the other side. And often the truth, the objective truth is somewhere in the middle, not always, but often. I'll hold your question because I'm only about halfway through.
Yeah, because I'll come back to that.
Come on! You
No,
want to go back to the first, the top?
yes,
Yeah, okay.
because that should be on a case-by-case basis too, but keep moving.
Well, even if it is, if, let's say you're deaf and my VRI is working perfectly and you go to sleep, the VRI doesn't have to stay in the room with you. If you need it, we will have already talked about how you can get it instantly if you need it, and all the other incredible communication methods that I'm going to be using. So you will have no trouble.
I just had a hospital stay with somebody and the lady next door to me was up all night long with issues and concerns and questions.
Could very well be, but it's my VRI device. It's not going to stay in the room.
Okay.
And even if it did, the code for how to log in, and I mean, I have the code, I'm not going to give it to you.
Gotcha.
So I don't really think that by itself gets you there.
Okay. Thank you.
You're welcome. I love this. And see if you can, reading it, why do I love it?
I knew.
Well, I knew is kind of damning.
Yeah, and he knew, the patient said that it was not effective.
Yes, and then what did they keep doing?
Kept trying to
They
use.
kept on using it. And they kept using it, but what would it continue to do?
Freeze
Yeah,
up
it
and
just
not
kept
work.
not working. So, yes, the I knew, like,
That's it.
when I read this,
At least they didn't laugh.
yeah, well, there you go. I would certainly hope that folks testifying under oath would not do that. That's another issue. So when I read this, I was the ADA expert for the hospital, and I called the hospital and said, there's no way we can get beyond this.
Yeah.
And I
Let's
think,
settle.
it's impossible. And why? Yes, you knew it was not working. So you have firsthand knowledge that an effective communication method is not effective. Patient said it. So you have two things. You knew it from firsthand observation, and the patient is telling you it's not working. Oh, we just kept trying to use it anyway. And it didn't work. But they kept using it over and over and over again. So this is one of the worst pieces of testimony that I've seen in an ADA case, probably ever. Mainly because of this. You keep trying to use it, keep doing the same thing over and over again. These are situations that the Justice Department loves these. They often, in settlement agreements, if there's a complaint, they will then require this particular hospital or healthcare provider, really any local state government, to say with the VRI, okay, if it's not working, you have like 30 minutes to get it to work, or 20 minutes, which isn't that long. If you can't, then you get an in-person interpreter. And those are the only options. But the issue about video remote interpreting not working correctly is also a big one. A lot of organizations don't know what the law of VRI is, and they don't understand that if there is an issue of freezing, for example, and it repeats itself, then if you allow the VRI to be used, that is illegal and discriminatory. So what is effective communication? As we've been talking about, yes, it depends on the circumstances and the patient, the treatment, the medical conditions, the length of the conversation, the complexity of the subject. There's no legal requirement for using an interpreter to explain what's on the hospital menu, for example. That's not complex, it's not going to take long, easy to do. But if I'm giving you a life and death diagnosis, that's going to take a long time, that's complex, you need an interpreter. And notice I'm not saying in-person versus video remote interpreting, it could be either one. But you better make sure that you're complying with the law for how to make video remote interpreting work and not be discriminatory. The best practice for compliance and risk management is you use an interpreter. That's the default position. Whether it's in person or by video is separate, but that's generally the best practice. If the patient can communicate or prefers to communicate in sign language, that's the default. And then you go from there. So these are the basic laws of video remote interpreting. These are federal regulations, and you can see in the citation is at the bottom. 28 Code of Federal Regulations, section 35.160. The first three are technological. Bandwidth, dedicated high-speed line, video images that don't produce lags, they're not choppy, blurry, or grainy, no irregular pauses in communication, sharply delineated image that's large enough to display the interpreter's face, arms, hands, and fingers, and clear audible transmission of voices. If any of these is not happening, that is illegal. Where you go from there is something else, because that's going to depend on not doing this. So if you have lags and choppy images, and you can't fix it quickly and go to an effective communication alternative and you keep using it and the problem just repeats, that's a problem. I still find invariably healthcare organizations don't know that. They don't, and they also don't know you got to train your folks on how to use the machine. If you're not training them, you may be in a situation that I've seen where you have doctors and nurses come into a hospital. They don't know how to work the video remote, and I've asked the patient, can you turn this on for me? Or where's the outlet so I can plug this in? These are not isolated, and it's not like they happen once every 20 years. It's surprising how often this happens, because often organizations don't do this, or they don't do it effectively so the staff actually knows what to do. And invariably, there are one or more of these problems. So there are other parts of the law of VRI, but this is the heart of it. Unless you know about this, you're already having problems, and you're kind of storing yourself up for greater problems in the future. And this is basically the standard. This is the Federal Appeals Court last year. So is the hospital or the healthcare provider affording the patient the aids and services that allow her to equally participate in and make choices about her health? You don't decide for me what communication is important and what communication I need to access. If I don't have the means to communicate with you effectively about my care, my diagnosis, that's for me. So this is the standard. You must give me the opportunity to participate in and make decisions about my care. This is another example of a case, and this is one of the surgeons I mentioned before, that this particular patient, again, using the video remote interpreting, and it's just not working consistently. So eventually here, the staff stopped using it because they couldn't get it to work right. The problem is that they didn't use a method that the patient thought was effective. They just started making gestures. Now, gestures can be an effective communication method in certain situations, but not as you're going into surgery. Come on. Now, in this case, the doctor was actually upset that he had no other method to communicate because the VRI wasn't working. Surgery was ready to go. They did not call for an in-person interpreter. He wasn't uncomfortable. He was uncomfortable, the medical records show in this case. But this was the method that she had nothing else to resort to. And he was very frustrated. This was one of the highlights of this particular court decision. These are examples of court decisions with problems, in these cases, with video remote interpreting. A visit generated a report which contains a note that this patient's deafness limited the medical evaluation. So there's something written down in an official medical record that the communication was limited because of the patient's deafness. So that patient is being treated differently because of his disability. That is discrimination. A physician wrote in his records his frustration that the VRI was not working for him. As you can imagine in a lawsuit, this is called an admission against interest. You're writing down in the record of the hospital, I'm pissed off that this didn't work and I had to do X, Y, and Z. How do you explain that? Oh, I didn't mean that. Forget it. Medical records reveal that communication with the patient was a problem. Well, if it's a problem, what do you do to fix the problem? Admittedly, sometimes reading thousands of pages of medical records can be challenging and not necessarily the main thing I like to do during the day, but they reveal an awful lot. And often they reveal comments like this. And I'm not suggesting that the comments not be made. That's not the issue. The issue is, what do you do? What did you do to fix it? How did you resolve the problem? Now I'm going to go over these somewhat slowly. This is a brand new case, brand new court decision that I think is really important about what is discrimination and what is the obligation to communicate effectively. So here, again, this is against the healthcare providers. The patient is claiming that the healthcare providers did not provide her with the methods for effective communication. So the court said, which is correct, the hospital is not required to provide whatever communication method the patient wants. So if I say I want an in-person interpreter 24/7 to communicate with me about everything, the answer is, I'm sorry, we don't do that. We have these communication methods for you. You do not have a legal right to an interpreter. You have a legal right to effective communication. There's a difference. Patients with disabilities are not entitled to the aid of their choice unless it is the only thing that can be used for effective communication, or that it's necessary for them to be able to communicate effectively. While qualified sign language interpreters may be the only communication option for some, there is no per se, and that means absolute. There's no absolute rule that such interpreters are necessary, and other accommodations other accommodations are often sufficient. The court is saying here, which is correct, that you do not have a legal right to an interpreter. There's no absolute rule that says that, no absolute rule that says that interpreters are necessary, and other accommodations are often sufficient. Now, are often doesn't mean every time. It's a case-by-case thing, and that is very, very true. It is case-by-case. So here, there were allegations that the video remote interpreting did not work on whatever occasions, for however long. The court said that any temporary failure of a VRI is not discriminatory. So remember we talked earlier about connectivity, and if the internet goes down, that's not by itself necessarily going to be discriminatory. So just because the VRI stops working, that moment is not discriminatory. What happens after that? Then you get into the weeds and get into the more interesting things that we've been seeing. Technology, of course, is imperfect, and the Department of Justice, the court said, understood that when it allowed for the use of video remote interpreting, which I think is correct. Delays and difficulties, yes, no question about it, there can be delays and difficulties, and that those are not necessarily discrimination. I want to pause so you can look at this. Now look at what this says. The court is saying that it's not necessarily illegal that the hospital is using something that eventually proves ineffective. So just use the video remote interpreting as an example. I'm choosing to use it because it's worked pretty consistently. The Justice Department approves it. If it's working okay, it's pretty good. But as we go forward, it just doesn't work consistently. So just because it doesn't work consistently after I decide to use it, that's not discrimination. But as you've seen, it can be if I just continue to use something that doesn't work. So the court is agreeing with that. Just because you use something that eventually proves not to work by itself, that's not a problem. And the court recognizes, which is true, that a hospital can communicate by using written notes. Again, case-by-case issue, and they're talking about it, if something is too complex, you can't use written notes. But this is the key. Only if the hospital failed to provide an alternative method, once it became clear that the first method didn't work, there's discrimination. So remember, it's what happens after. It's not that first attempt, that first effort, it's what happens after. And this is what I think is particularly important. In this case, the court said, you know what? I think there was discrimination. I think there was. But the court said it doesn't matter. Because to recover money damages for disability discrimination, you have to prove intent. That I intended to discriminate against you. It's not an accident. Like that hospital VP put up the sign that says, if you want an in-person interpreter, you have to pay for it. That's a pretty good example of intent. So here the court says, let's assume the VRI didn't work in the same way that the patient said. Let's just assume that's true. But did the folks who run the hospital know that? Was it an isolated thing? Was there something else that was used to communicate? So here the court said in one of the first rulings about what is exactly intentional discrimination in healthcare, no evidence that to conclude that the staff members regarded the issues of communication as anything other than isolated. So no example of they just kept using the VRI over and over and over and over and over again, and it never worked. And even if they viewed the problems as being big deals, there's no evidence that they told anybody. So the hospital, the leadership, they didn't know that anything was happening over and over again. The staff didn't think that was a problem. Now I know that the patient thinks that it was, but the court said you can't, they didn't prove it. Excuse me, there's no evidence that that happened. So this court is saying, even if there's disability discrimination, that doesn't mean that you win. That doesn't mean you recover money, because you cannot prove intent. And as we see here, can't prove intent, you lose. So the court dismissed the case and granted what's called summary judgment to the hospital. Very, very important case. That's the first case that I think court decision that I've seen that says, I think there was discrimination here, but that's not enough. Pretextual discrimination. I'm coming to the end, so we can take a break and then we'll do questions. Pretextual discrimination is using an excuse to cover my discriminating against you. So this is a small healthcare clinic. They had a policy against any animals coming into the examination room or into the lobby area of the clinic. And they said, got a concern about infection, got to keep a sterile environment. Dogs have a lot of bacteria and they can hurt our patients. Well, this particular patient said, wait a minute, that's not. So the patient sued and hired an expert who said that the Centers for Disease Control said in a report that, which is correct, that as human beings, we have more microbes of bacteria on our skin and clothes than a dog does. So if you're going to bar dogs to maintain your sterile environment, I guess you're going to be barring people too. So the court looked at that and basically said, are you sure you want to go ahead with this case, and this case eventually settled. But they used as a pretext this, when what they really wanted was, we don't like animals, and we don't want them. Pretext excuses happens all the time as explanations for behavior that may be discriminatory. And here they clearly were discriminating against people with disabilities who use service animals. I'm going to deviate a little bit from the ADA and just talk briefly about some other issues that have come up this year. In July, this is the first case under the Affordable Care Act, Section 1557, claiming national origin discrimination because this particular hospital, which is a very big hospital, did not provide any kind of interpreter and did not provide translated discharge instructions. This particular patient speaks Chinese. So I've been waiting for a case like this. I've been surprised that all of the discrimination cases in communication and healthcare are on behalf of people with communication disabilities. This is the first one involving someone who speaks a language other than English. I expect this will not be the last case. I expect that my lawyer colleagues are going to be filing more of them as they discover that, wow, this makes it easier for us to sue and win. How come we haven't been doing this? That was the explanation in this case. I expect more lawyers will come through a similar conclusion. Talk a little bit about LGBT discrimination. A lot of things happened this year. Several major federal court decisions that have found that federal law does prohibit discrimination based on sexual orientation or sexual identity. The Supreme Court has not weighed in on this issue yet. Until they do, then you follow the rulings of lower federal courts. This is the one area in healthcare that every single hospital, every single provider, every single clinic has said the same thing. We're not prepared. We're not prepared for what do we do with a patient who's transgender? How do we handle them? Every single one, no exception. Meaning that, how do we talk to them? What name do we write down on the medical records? What room do we put these people in? And these are the conversations, this is literally what people ask me. It is amazing, and part of my scholarship at Georgetown is we talk a lot about working with patients who are transgender and how that is one of the newer issues of discrimination. We talk about why, and why many people are just very uncomfortable in handling situations involving patients who are transgender. And this is another example of another case this year of gender identity discrimination. What I like about this case, what's very unique, this is a decision by a court of appeals court in Philadelphia. There was an argument, the lawyers came in, they made their argument to the court asked questions of the lawyers, thanked the lawyers, they left the room, closed the door, the court said, we're ready to make a decision. They never do that. So they decided literally within minutes of the case being done that there was transgender discrimination based on gender identity. And this is really part of a larger trend nationally, in the vast majority of the courts basically decided the same thing. And that's the question that I always ask. I ask my students, I ask my audiences, I ask the physicians, I ask the leadership folks when I do presentations to them, what do you do? What do you do in all these situations that we've talked about today? There are a lot of situations we obviously have not discussed. What do you do? The correct answer is, I don't know, or nothing. Or we just keep hammering that damn VRI machine until we can get it to work. Those are not the issues. Or with someone who's transgender, as has happened in other cases, well, we're just so hostile to them. We're not only hostile to them, we inflict physical pain on them. There are cases that involving people who are transgender, where the healthcare providers actually inflicted physical pain to such an extent that federal judges have likened this to a criminal assault. So the answer to this question is not in this situation saying we hurt you. The answer is, you better figure out what the answer is when these issues confront you, which they will. So everything is revealed once you get into court. There are no secrets. It is amazing what thousands of pages of records will show, and you've seen some examples of that today. To close, this is also just an astounding bit of testimony. It's a hospital vice president case involving a hospital and deaf patients. So the Q is the lawyer, the A is the VP. So in the last 4 years, can you recall having any training about disability policies or laws? No. Once you have a policy, how do you monitor compliance with it? Well, you train on it. Now remember, no training. Okay? So how do you monitor compliance? You have training. So did the policies themselves specify what kind of training? No, not yet. Okay, what about training for healthcare staff about dealing with patients or companions who are deaf? Are there trainings? I haven't found any. So you're not aware of any say in the nursing department since your tenure. No, we go by our policy. But your policy, remember, includes monitoring compliance by training. So how do you go by your policy if you have no training? This case did not end well. And it's also not an outline for really any organizations about training and policy. So to conclude, if your policies or plans say something, make sure you do it. Not like what we talked about at the beginning, that list of 20 situations where you provide an interpreter. We provide an interpreter all the time, but we didn't do it here. If your policies say it, then make sure you do it. And if they need updating, do it now. Because if you get sued, it's going to come out that you have not updated your policies. And you don't know what the new requirements are. And that can be a stepping stone to proving intentional discrimination. And here, a good quote from the U.S. Court of Appeals from the Fifth Circuit. The executive vice president testified that the hospital's ADA compliance policy was in need of revision. So she testified she knew it needed to be revised. She also testified that she was unable to find any training sessions that took place about working with people who are deaf. And she also testified, well, I couldn't find anything about updating the policies. So you know a policy needs training and needs updating. You haven't done it. You know you need to train on it. You haven't done that. Okay. So this is one of the best pieces of advice from my Justice Department colleagues. Training has to be good training. Not 5 minutes, oh, by the way, X, Y, and Z. Not new employee training regularly, often, in many different ways to capture people's learning styles. Otherwise, it's just not going to sink in. But as I said, it's more than new employee orientation, ongoing training, lots of reminders. And I use this in every presentation. Don't repeat this mistake. This particular healthcare company was sued for violating HIPAA. And the company says that it obeyed HIPAA and was compliant because it trained its employees about HIPAA. And that because of this training, they understood what HIPAA said. But the court said, even if the training were flawless and no evidence suggested it was even adequate, staff training does not compensate for missing policies. So here, the court said they have no policy. The company says, oh, we have them, and we train them. The court said, and your training stinks. So where are we? $500,000 plus cost of insurance. That's me. That's my contact information. It's 10:25. I would suggest, why don't we can take like a 5-minute break, and then we can come back and you can flood me with your questions. Okay, thank you. So 5 minutes, we'll come back at 10:30. Okay, questions?
Do you think if the ACA laws ever repealed or modified, will the laws not be so rigorous?
It will never be modified to get rid of what we've been talking
No, I mean, not the protected class, but you mentioned how strict they have gotten it since ADA.
about. Oh, you mean since the Affordable Care Act passed?
Yeah.
So the standard under the Affordable Care Act that gives healthcare providers, for example, brings them up to the same category,
Right.
is a federal regulation. That can only be changed through a very long, drawn-out process. I haven't seen any evidence that that's happened. The protected categories under the Affordable Care Act were passed by Congress. The only way those can change is they have to be repealed by Congress and signed into law by the president. There's no way that's going to happen. There's never been any civil rights law that I'm aware of that has been repealed. So I don't expect this to
No,
happen.
I don't, I'm just saying if ACA itself as a law
Right.
is repealed or watered down, what do you think? Because one of the things that you mentioned is that the hospital systems had to come up to the level of oversight of city, the state, the county, right?
Right, so the only way that would change, since the standard that brought them up is a regulation, that can only be changed by the Health and Human Services going through another regulatory process to change that. That's a very complicated process. I don't see that happening.
Gotcha.
I haven't heard, yeah, I haven't heard about that. I think there may be an attempt to change the regulations regarding transgender discrimination. I believe that is going on now. But that also is a long, drawn-out process. That hasn't concluded. But I haven't heard that they're also going to do that with regarding disabilities.
Yes, and regard the one single case about the LGBT first institution, why not sue under Title VI of the Civil Rights Act? Why the Affordable Care Act?
That's a great question. Basically, the legal requirements are the same for spoken language assistance. Title VI of the Civil Rights Act of 1964 mandates language assistance for people who are limited in each profession. Section 1557 does the same thing. The difference is that under Title VI, I have to prove intent to win. Under 1557, I have to prove disparate treatment. Big difference. It's harder to prove intent than disparate treatment, which basically means you're treating me differently because I don't speak English. Which if I'm suing, claiming you didn't provide translation, I'm already doing. That's why lawyers are using the Affordable Care Act more, because the standard to win is lower than intent. It's disparate treatment. So that's why. I think that just like all the areas that we're talking about, these are specialty areas of practice. Most lawyers don't have federal court practices, and they tend not to be as familiar with federal law as state law. So it's just taken a while, I think, for them to catch up. Every case that I have under the ADA has also added a claim under the Affordable Care Act. And as I've explained to the lawyers who are representing the providers for the most part, that's because the standard is different. They can win easier under the ACA than under the ADA. Same thing, they can win under the ACA easier than under Title VI.
So to your knowledge, the only case of LEP case out there is this one, because I mean, in my 12 years in the underserved units, I have never seen a case despite the fact we have awareness of Title VI, the class standards, the executive order, and the 2001, the CMS guidelines on Title VI. So there's quite a few things out there, but there's never been a lawsuit to your knowledge except this
Or
one.
no, that's not true. I said this is the only case I'm aware of under 1557. I know about a lot of Title VI cases, including in the state, claiming discrimination against healthcare providers because of language. I can't talk about it because they're not public, but and I've been an expert in Title VI cases against healthcare providers. So there have been Title VI cases, not 50-57, until July. That was the first one that I knew. Anybody else? Yeah.
I know, a few questions. My name is Kyra Fisher, I'm from Salvation Army.
Right.
We do substance abuse treatment, it's a little different from standard healthcare. So right now, we have a Spanish-speaking person who's in detox, wants to go to residential. And we're trying to figure out how do we provide effective services for this individual. So we will get an interpreter, and we have groups from 8 to 3 or 5 therapy groups with other English speaking persons. And so we're trying to coordinate services with Bromberg, the whole system with the transmitter and everything. And we're trying to figure out what do we do in the meantime, because we're a 24/7 facility. And the interpreters will have them available during the day for group, but what about when they go to dinner? And in the meantime, when they need something from the unit monitor, and do we need to dial up telephonically the interpreter? So we're making sure that we're providing adequate services. What do we do? And what's your advice?
Well, the first thing is that you should have written policies on exactly what you described.
Yeah,
And that's, do you have it?
we're updating the policy. Our policies are very outdated. And so we met in, I don't know, maybe 20 years. I've only been there 6. We haven't had to provide interpreter services, which, yeah, so it's like we created policies, but not based on actual
Sure.
service. You know what I mean? It's just
Sure.
like, let's create a policy and, oh God, it's not working. We gotta change
Okay, so yes, policy, you should get a lawyer to review policy before you actually look at it. And providing interpreters, although the laws are somewhat different, you have to think about the more involved, complicated conversation. So if I have a question about, where's the restroom, you're gonna need an interpreter.
Right.
But what you do need is to train your staff on how to handle these types of communication. And what do? Because what a lot of folks do is they have to use a lot of universal symbols for the simpler communications. And they have placards or whiteboards where someone can write something down. For basic conversation, that can be fine. But in order to make sure that when you're getting into the complex stuff, that you're providing qualified interpreter, policies have to address it, and you need someone to review them to make sure they're compliant.
And then this whole rollout of section 1557, it's a little different for substance abuse providers because we're not under J code, we're under different accreditation when it comes to substance abuse. So we got a checklist from Bromberg and Associates, and there's a few things on here that we don't understand, and from a provider point of view, substance abuse treatment, they don't really understand. And we're just like trying to put policies together. So it was a few questions I had when they talked about does your organization have a legally accessible website for disabled people to comply with section 1557? When they say legally accessible website, what does that really mean?
You missed part.
Yeah, I'm sorry.
See, now I know why.
Yeah.
I don't want to take a lot of time, but you can,
Yeah.
we can talk about it. Okay. Basically, that's the ADA, Americans with Disabilities Act, and 1557 require that your website and your online materials be accessible to people with disabilities. So if I can't see, or if I can't hear and you post videos on your website explaining your program, that's part of it. But the whole legally accessible website thing is blown up the last few years and has become a big source of litigation. So if you email me, we can figure out it. We'll communicate.
Okay, great.
Anybody else? Questions? No? Good. All right. Yeah.
I have off the record question.
An off the record question?
When the classes.
Okay, well, then we'll have an off the record conversation because I am a Michigan licensed attorney. So we could do the full attorney client privilege. No more questions? Well, if you have questions, please call me, email me. It's been a pleasure. Thank you so much for coming and have a great rest of the day.
Thank you.
Thank you.